After nearly a 2-hour discussion on the stormwater utility fee, council members grilled the parish attorney, his office, and the mayor. Why was the public and the council being led to believe that there was a non-disclosure in place, preventing everybody basically from telling the public about a fee that they would have to pay for, thousands or even tens of thousands of dollars? Andy Dotson, the parish attorney, pretty much said repeatedly that it was Federal Article 408 keeping him from disclosing details.
It's stamped as such at the top, stating that it should not be released pursuant to Federal Code of Evidence, Article 408. Article 408 of the Federal Code of Evidence specifically speaks to the fact that lawyers are not able to disclose confidential negotiations.
That's like me looking at a law and saying, even though I know it's a hammer, it's a wrench.
Franz Borgard is a state and federal criminal defense attorney and legal expert who is familiar with Federal Article 408.
That article does not deal with disclosure of discussions about settlement or make confidential those conversations. What that article does is, in the event the settlement doesn't happen, you can't use things said at the settlement negotiation in a proceeding or a trial.
In simple terms, Beauregard says Article 408 only prevents evidence and or conversations from being admitted into court during a trial or hearing. For example, if an attorney tells the prosecutor that his client is possibly guilty, that is protected under Article 408 and cannot be used in court. It does not keep things confidential, that you cannot talk openly or disclose information to the public or council members, meaning it is not a non-disclosure agreement.
Either it is a misstatement of law, a misinterpretation, misstatement of law, or it is someone trying to mislead the council, because that article does not apply to what he's talking about. Andy Dotson's a very competent, bright, and I believe professional and ethical attorney. I'm a little confused about why he is saying 408 applies. That is what I'm confused about. He is a very smart, a very intelligent attorney. I don't think that he would be misguided in that.
Dotson has been the parish attorney for East Baton Rouge since 2019. Now, though, Councilman Cleve Dunn requested the process begin to potentially remove Dotson as the parish attorney, saying confidence in him has eroded over the stormwater utility fee.
Our concern is ensuring that the federal government has certainty that the city parish is not releasing information that it should not. It was our opinion and our belief that the best way to do that was to have all non-lawyer individuals, including our clients, sign NDAs.
But two federal agencies, the Environmental Protection Agency, or EPA, and the United States Department of Justice, or DOJ, both told Congressman Garrett Graves they did not require anything be kept confidential.
They made it crystal clear to us there is no non-disclosure agreement required by the federal agencies. And so if there's any non-disclosure agreement that exists, that it is not because of any federal agency requiring.
I do think that the NDA was designed to conceal information and keep secret certain things. That's what an NDA does by its very nature. But that, let's not mince words, that was a choice, not legally required. Now, why that choice was made, why the choice was made to not share that information, is a question that only Mr. Dotson in the parish attorney's office can answer.
Unfiltered with Kieran has repeatedly reached out to Dotson, but so far, no response. Going off of what he said at the last council meeting, Assistant Parish Attorney Bob Abbott felt after talking with the EPA and DOJ that in order to keep from disclosing information, a non-disclosure would be best, and that Dotson agreed with him. Abbott's job is also now being questioned by council members.
If you would disclose the information to an outside party, now I have to deal with the federal regulators wondering how this confidential information, which you assured us was not going to get out, has gotten out, and that may potentially hurt us down the road and lead the city to having to incur a cause of action because of that release of information. So we felt the safest way and the best way to show the federal government that we relayed that information was to have all non-lawyer personnel sign it, including members of the council.
If the feds are saying we never required an NDA, well, then that means who wanted the NDA? Well, Mr. Dotson in the parish attorney's office.
What the NDA was to keep from the disclosure of, as I said earlier, confidential settlement discussions between the DOJ and our office.
But saying the NDA was because of Article 408 does not apply according to Beauregard.
I think the public has the right to have that question that you're posing. Why was this done? Answered. Because what it is it demolishes and destroys transparency, right? And I think that's why a lot of the members of the council are upset. The council represents who? The people. So now the council is sitting there saying, well, wait a minute, this doesn't smell right, this doesn't sound right. And they're being told by their counsel, well, no, it's this legal reason why I couldn't give away the information. But the truth is the legal reason that's being provided by Mr. Dotson in the Parish Attorney's office, that's not what the law prohibits or requires.
The transparency is not there. The trust between the public and public officials is not there. There's trust that's been taken away between the council and the administration's office. All that does irreparable harm in what we need to do.
This is really eroding trust.
With Unfiltered with Karen, I'm Karen Chawla.